Here are 5 ways you can mess up a will. First is vague wording. When you draft a will, you need to be very careful with the wording. The language needs to be very clear and very specific. It doesn't have to be in legalese, just clear and specific. After you pass away, a judge is going to read your will. The judge should be able to get a clear picture of exactly what you wanted. Your will should be a clear and specific guide to the judge and to your loved ones. Next is forgetting assets. It's not hard to leave something out, and this is especially true for assets acquired after the will is written. Does your will account for those acquired assets? If you leave out the language to handle those, then either the judge or state law will determine who will get what. It only takes 1 paragraph to make sure that those assets go to who you want, how you want, when you want, and in the amounts you want. The third mistake is to put the wrong people in charge. You need to select an executor that can say no and control the family. It might even need to be somebody outside the family, maybe even a professional. Many banks will do this for you. Fourth is not keeping your will or your plan up to date. There are many reasons you need to update a will. The birth of a child, the death of a child or beneficiary, new major asset purchases, or severed relationships are a few of the reasons. And 5 is not keeping up with your will. You can put your will in a place that is too safe. You need to make sure your children know where it is. If it is in a safety deposit box, they need to have access. And most courts require an original signed copy of your will. I'm Gary, the founder of DeWitt Law. Learn more at dewitt.law/estate planning.